So, very good morning, friends.
Very
Today we will be having, there is some echo. So, please mute yourself. All the participants are requested to mute themselves. Uh, Today we will be starting with the Supreme Court case laws. I think 6 case laws we already covered yesterday. Now is 7th in the series. This 7th case law, it relates to Shivam Water Treaters Private Limited versus Union of India. So, in this case, special civil application was filed before High Court regarding validity of NCLT and constitutional validity of IBC. And then High Court referred this matter to Supreme Court. So one of the questions here was whether High Court can examine the relief sought for with regard to validity of provisions of code and constitutional validity of NCLT, because various provisions of code and the constitutional validity of NCLT was challenged before High Court, but High Court referred the matter to Supreme Court. So Supreme Court in this case said that High Court should address the relief to any action by the respondent on any order passed by the NCLT, but it should not go into debate pertaining to validity of the various provisions of IBC, which is the domain of Supreme Court. Because sometimes what happens is NCLT passes an order and High Court, it is very well within the jurisdiction of the High Court to see that the relief which was sought on any action in pursuance of the order passed by NCLT, whether that has been granted, whether that relief has been addressed, whether that relief has been granted. So to that extent, High Court can interfere into any judgment. But suppose question comes regarding the validity of the provisions of IBC, etc., then High Court need not go into that debate because it is not in their domain. So this was the brief of this case. Next case was regarding BK Educational Services Private Limited versus Parag Gupta and Associates. So in this case, the issue was that NCLT held that Limitation Act is not applicable for initiation of CIRP. Limitation Act as such is also in our syllabus. But here the NCLT was of the view that Limitation Act is not applicable for initiation of CIRP. So one of the issues which came was whether an application under Section 7 of the Code can be filed before adjudicating authority in respect of a debt which is barred by Limitation Act. And the decision was yes, it can be filed. Because as we know, as per the provisions of Limitation Act, any delay, if justified, can be condoned in pursuance of Section 5 of the Limitation Act. Another question was whether Section 5 of the Limitation Act is applicable to CIRP. Suppose a person is not able to file an application under CIRP because of the limitation period having expired. So whether this section, by virtue of Section 5 of the Limitation Act, whether that delay can be condoned and application can still be filed. So Supreme Court held yes, it can still be filed. Another issue was whether Section 238A, which was inserted on 6/6/2018, is applicable retrospectively, because Section 238A, Section 238 we all know is non obstante clause. And Section 238A was introduced at a later date because there was a lot of confusion regarding this Limitation Act. And 238A says that the provisions of Limitation Act shall, as far as may be, apply to the proceedings or appeals before the adjudicating authority, NCLT, DRT, or DRAT, as the case may be. So 238A was made applicable. The enforcement date was 6th of June 2018, but it was presumed that this is applicable from the very inception of the code. And there is a case law also. There are 2 case laws on this. Contrary to the judgment passed by Appellate Tribunal, Supreme Court held that Limitation Act is applicable since the inception of the code. Supreme Court noted that the Insolvency Law Committee report of March 2018 makes it clear that the object of the code from the very beginning was not to allow dead or stale claims. It is, of course, true that dead or stale claims cannot be entertained. They cannot be resuscitated. It held that the right to sue accrues when a default occurs. If the default has occurred over 3 years prior to the date of filing of the application, then application will be barred under the Limitation Act. In case where there is a delay, Section 5 of the Limitation Act may be applied to condone the delay in filing such application. So, under Section 5, an application can be made justifying the reasons for delay, and once that delay is condoned, then application, of course, can be filed. And this Limitation Act was set to be applicable from the very beginning. Another case in the matter in this case was limitation under the code. The right to apply by virtue of Article 137 of the Limitation Act of 1963 commences on or from 1st of December, that is the date when the code came into force. This was decided in NCLAT, Neelkanth Township and Construction Private Limited versus Urban Infrastructure Trustee Limited Company Appeal Insolvency. So these were the two cases. One was BK Educational and another was this Neelkanth Township and Construction Private Limited versus Urban Infrastructure Trustee Limited. And some other principles which were decided was that Section 433 of the Companies Act specifically applies the Limitation Act to the tribunal and appellate tribunal, including NCLAT, insofar as applications or petitions are filed under Section 7 and 9 of the code. NCLAT will decide such applications on the footing that the Limitation Act will apply to the same. Okay? So these were some of the issues which were decided in BK Educational Services Private Limited. Next case was this Chitra Sharma versus Union of India. The brief facts of the case were that home buyers, they have the effect of commercial borrowing. Yesterday also we discussed Section 5, subsection 8, subsection F, that home buyers, it has the effect of commercial borrowing, but ordinance came after the expiry of the CIRP period in this case. In this case, when this ordinance came, CIRP was already over. But SC invoked its special powers which are granted to the Supreme Court under Article 142, and they included the home buyers in the COC. So the issue was whether Supreme Court has the power to revive period prescribed by the code by another one it is, because in this case CIRP period was already over when this ordinance came. But yes, the Supreme Court held that yes, by virtue of Article 142, Supreme Court has the power to do anything in the interest of justice. Next case was Anuj Jain, IRP for GIL versus Axis Bank. In this case, actually, as we know, in case of construction companies, land bank is owned by one company and construction is done in some other companies. So in this case, JP Infratech Limited, they mortgaged its land because JP Infratech Limited, GIL was having the land bank and the projects were being executed by Jayaprakash Associates Limited, JAL. So JIL, which was holding the land bank, mortgaged its land in favor of Jayaprakash Associates Limited. And IRP filed application for reversal of this mortgage because once this GIL came under CIRP, so the IRP appointed for GIL filed an application for reversal of mortgage, stating that these are PUFE transactions because these transactions have been entered into between two sister concerns, between two related parties. Adjudicating authority allowed the application, but NCLAT set aside the orders of NCLT. Now this matter went to Supreme Court. So the question here was whether transaction in question regarding mortgage of its land by GIL in favor of Jayaprakash Associates Limited, whether it is a PUFE transaction or not, and whether these transactions are covered under Section 43, 45, and 66 of the code. Supreme Court said yes. Court noted that even when furnishing a security may be one of the normal business practices, it would become part of ordinary course of business of a particular corporate entity only if it falls in place as part of the undistinguished common flow of business done and is not arising out of any special or particular situation. So in this, it said that, okay, suppose you furnish a security, then it may be a normal business practice. But here the situation is not so, because the mortgage has been done by one company in favor of its another company, which is its associate company. And that JL, it has mortgaged the mortgage received from JIL to its creditors. And now creditors of JL are representing before IRP of JP Infratech Limited to be included in COC. So another issue here was whether financial creditors of Jayaprakash Associates Limited who have been mortgaged the land which originally belonged to JP Infratech Limited, which is now under CIRP, whether they could be recognized as FC of JIL. So Supreme Court said no. You will not be included as FC of GIL, and you will have to return the land which has been mortgaged to you because it is a PUFE transaction. So no mortgage of property can be a debt under section 3 subsection 10 of the code, but is not and can't be a financial debt within the meaning of section 5(8) of the code. So they say this mortgage of property, it could be a debt under section 3 subsection 7, but it is not covered under the definition of financial debt. So the financial creditors of JAL cannot be considered as financial creditors of JIL, which is under CIRP, and they will have to return the land which they are holding as mortgage. Other principles was that the class of financial creditors shall be either principal debtors or assignee of principal debtor. Next case was Swiss Ribbons Private Limited and another versus Union of India. In this case, various issues were there. So the first issue was that the appointment of members of NCLT and NCLT, they challenged the appellant challenged the appointment of members of NCLT and NCLT, but Supreme Court held that this appointment of members of NCLT and NCLT is being held through a selection committee and hence it needs no interference. Second point raised here was that the administrative support is coming through Ministry of Law and Justice, but it should come through instead of MCA. So Supreme Court agreed that this needs to be rectified. Another issue was that NCLT should be in every state because you have abolished the powers of High Court, because High Court is not having any jurisdiction, but NCLT is not there in every state. So NCLT should be established in every state. So Supreme Court agreed that yes, this needs to be rectified. And we shall soon establish circuit branches all over India. Another issue raised was that there is no real differential between financial creditors and operational creditors, because a creditor is a creditor. So why you are making a distinction between a financial creditor and operational creditors? But Supreme Court said that intelligible differential is allowed even under the Constitution. So as per the constitutional provisions, if we take some examples from the Constitution, then if you can differentiate between two classes, then you can offer different facilities or different criteria or characteristics can be put to them. Like suppose some is economically weaker section or for it's a minority, then you make a distinction. So here also there is a difference, there is a distinction between financial creditors and operational creditors, and this is based on intelligible differential. The criteria for applying under section 7 and 9 is different, and there are so many other things. Next was whether notice be given to CD before passing an order for initiating CIRP, and at what stage the set off or counterclaim be considered. So they said because while admitting an application under section 7 in IBC, it was written that notice need not be given to CD before passing the order. If all the conditions are satisfied, suppose default is triggered and the application is complete in all respects, then adjudicating authority can straight away accept the application without reverting to CD, and no notice need to be given to CD before passing an order for initiating CIRP. And another question was, at what stage the set off and counterclaim be considered? So they said at the time of section 7, subsection 5. Another question was regarding section 21, constitution of COC, and whether these meetings of COC, whether they are discriminatory. Those it said no, these are not discriminatory. Another question was whether section 12A derails the settlement process by requiring approval of at least 90% of COC and is violative of Article 14. Because we all know that as per the provisions of section 12A, once an application has been admitted, it can still be withdrawn with the approval of 90% of the COC. So the question here was, if you are allowing the withdrawal of application, whether you are delaying the settlement process because you have made this condition very stringent that at least 90% of COC should agree, and this is violative of Article 14. So Supreme Court said, no, this is not violative, and NCLT or oblique NCLT can always set aside order under section 16. Another point was regarding establishment of information utilities. Information utilities, we all know, it is basically a repository of financial information. As of now, there is only one information utility, National E-Governance Services Limited, NESL. So it said that this establishment of information utility is very much valid. Another question was whether powers given to RP of adjudication or, under the code and regulations grant of adjudicatory power to a non-judicial authority is violative of basic aspects of dispensation of justice and access to justice. Because they said that you are giving adjudicatory power to a non-judicial authority. You made RP in charge of everything. So why you are giving so much power to RP? Whether this is arbitrary, whether it is violative of basic aspects of dispensation of justice and access to justice. So Supreme Court said that, okay, RP has got no adjudicatory power. It is basically in an administrative capacity only that is functioning. Section 18 lays down duties of RP, even under Regulation 35A, RO to make a determination and apply to adjudicating authority for appropriate relief. So even in respect of these PUFE transactions, RP has to make a determination and he will apply to adjudicating authority for appropriate relief. So RP as such has got no adjudicatory powers. It has got only administrative powers. Next question was whether this section 29 is contrary to objects sought to be achieved by the court. So it said no, this section 29 is not at all contrary to the objects of the code. Next was whether this actually this should be section 29A. So section 29A, whether it is to be applied retrospectively. So Supreme Court said yes, it is to be applied retrospectively. Next was whether section 29AC is restricted to malfeasance. So then it said no, because 29AC, if you see, it talks of, I think, NPS. Yes, 29AC, it talks of NPS beyond a particular period, 1 year normally, and in case of a financial entity or bought in persons of resolution plan for 3 years. So it said that this 29AC is not restricted to malfeasance, and RA resolution applicant can apply provided he pays all his debts as per 29AC. So even if there are some NPS, so a resolution applicant can very well pay them and then can become a resolution applicant. There is no bar as such. Next was Whether definition of relative should be nocitors assis with the categories of persons mentioned in explanation 1 to section 29A(j). So it said that related party would include only the persons connected with business activity of the resolution applicant. Suppose there is a related party, there is a person which is not connected with the business activity of the resolution applicant, then in that case there is no bar as such. Next was whether exemption granted to MSME from section 29A is valid. It said yes, because as we know, as per the provisions of section 240A, 240 capital A, if CIRP of an MSME is going on, then this clause C and H are not applicable in their cases. Clause C refers to this NPA and clause H refers to invocation of guarantee. So both these clauses are not applicable even if the resolution applicant is suffering from any of the disqualifications which are mentioned in 29C and H. Even then he can become a resolution applicant. Another point was whether section 53 it violates article 14. So it said no, this does not violate the, because section 53, as we all know, it talks of waterfall mechanism and it specifies certain modes of payment, that this is the order of payment to various stakeholders. So it said that this is not at all violative of article 14. Next case was Babulal Vardharji Gurjar, appellant, director of respondent, versus Veer Gurjar Aluminium Industries Limited. So in this case, the issue was whether section 18 of Limitation Act can be applied to code. So it said that no, prima facie, it appears from illustrative reference of section 18 of Limitation Act, para 21 of Jignesha had only be in relation to the suit or other proceeding wherever it could apply and where the period of limitation could get extended because of acknowledgement of liability. So it says that and application is time barred is here since 3 years have been elapsed and date of default is date of account declared NPA. So it said that this in this case the application is time barred since 3 years have elapsed from the date of default. And date of default here is date of account being declared NPA. Just a minute. The main issue here was whether the application which was made by Veer Gurjar Aluminium, whether it is within the limitation period. What was the analysis and what was the decision? It said that when section 238A, as I already read some time back, it relates to limitation period being applicable to IBC from the very beginning. So Supreme Court held that when section 238A of the code is read with consistent decisions of this court in Innovative, BK Educational, Swiss Ribbon, etc., then the following basics undoubtedly come to the fore. First is code is a beneficial legislation which is intended to put the CD back on its feet and is not a mere money recovery legislation. Second is the CIRP is not intended to be adversarial to the corporate debtor, but it is aimed at protecting the interests of the CD. Third is that the intention of the code is not to give a new lease of life to debts which are time barred. Next point is that the period of limitation for an application seeking initiation of CIRP under section 7 is governed by article 137 of the Limitation Act and is therefore 3 years from the date when the right to apply accrues. That the trigger for initiations of CIRP by financial creditor is default on the part of the corporate debtor. That is to say that the right to apply under the code accrues on the date when default occurs. That default referred to in the code is that of actual non-payment by the corporate debtor when a debt has become due and payable. and that if default had occurred over 3 years prior to the date of filing of the application would be time barred except in those cases where on facts the delay in filing may be condoned as per section 5 of Limitation Act. And an application under section 7 of the code is not for enforcement of mortgage liability, and article 62 of the Limitation Act does not apply to this application. Because as we know, for for mortgage cases, the limitation period is 20 years instead of 3 years. And date of default, they said, will be the date of NPA. So another question was whether section 18 of the Limitation Act could be applied to the present case. So prima facie, it appears that reference to section 18 had only been in relation to the suit or other proceedings. They refer to the judgment in Jignesh Shah also, and they said that it had only been in relation to the suit or other proceedings wherever it could apply and where the period of limitation could get extended because of acknowledgement of liability. Noticeably, in contradistinction to the proceedings of a suit, this court observed that a suit for recovery, which is a separate and independent proceeding, distinct from the remedy of winding up, would in no manner impact the limitation within which the winding up proceeding is to be filed. Next case we can see is case Sasidhar versus Indian Overseas Bank. So in this case, the issue was that NCLT affirmed the order passed by NCLT of rejection of RP and passing liquidation order. The COC passed the resolution plan with 66.69%, 55.73% present, and 10.94% on email. So in this case, NCLT had affirmed the order passed by NCLT of rejection of resolution plan and they passed the liquidation order, and COC had passed the resolution plan with 66.69%. So issue was whether this percentage of voting share in section 30 subsection 4 is mandatory. Supreme Court held yes, because this was a case when the pass percentage, the voting percentage for passing or approving of the resolution plan was 75%. But at a later date, it was reduced to 66%. So the question here came that once a liquidation order has been passed and now this amendment has come, reducing the voting percentage from 75 to 66, whether it can be applied retrospectively. It said no, it cannot be applied retrospectively, and this amendment dated 6th June 2018 is prospectively. So in case a resolution plan had been passed with 66.69% majority, which is more than the what is required by the amendment, but this was prior to the amendment, so this cannot be made retrospective, and this amendment is prospective, and once a liquidation order has been passed, it will stand as it is. And this percentage of voting share in section 30 subsection 4 is mandatory. Supreme Court held yes. Next was whether adjudicating authority can require any other factor than mentioned in section 30 subsection 2 and 61 subsection 3 of the code. So it said on receipt of rejected resolution plan, adjudicating authority has to pass liquidation order. Okay. On approved resolution plan, adjudicating authority has to examine within section whether it is within the provisions of section 30 subsection 2. So once COC has rejected a resolution plan, adjudicating authority has no power except to pass the liquidation order. But in case COC has approved any resolution plan, then still adjudicating authority will see the compliance with the provisions of section 30 subsection 2. Another point was regarding the role of resolution professional in resolution plan. So it said the power of the RP is to vet and verify the resolution plan in compliance with the provisions of section 30 subsection 2. He is not to express an opinion on matters within the domain of COC. Next case was regarding this Union of India versus Association of Unified Telecom Service Providers. So this is a case where the use of spectrum is being made by the company. So the question here came whether spectrum can be subjected to proceedings under the code. So in this case, Supreme Court framed some judicial questions and asked NCLT to examine the same. And in case of sharing, how the payment is to be made by the telecom service provider. So it says that shared operator telecom service provider cannot be saddled with the liability to pay the past dues of the AGR of license that have shared the spectrum with the original licenses. Because as we know, in case of this spectrum companies, in this case of telecom service providers, some sort of sharing is also done. So whether the shared operator telecom service provider, whether it can be saddled with the liability to pay the past dues of the licenses that they have shared. This was also the question. So they said the shared operators telecom service provider cannot be settled with this liability. And in case of trading, how the liability of seller and the buyer will be determined. In case they said part of the spectrum is under sale, liability of the buyer with respect to past dues of the seller shall not arise. Because it said that, okay, let us make a distinction between the dues which are uh, due up to the insolvency commencement date and dues thereafter. And in case entire spectrum is sold, past dues of seller is liability of buyer, except the amount, if any, found recoverable after the effective date of trade. And in such a situation, the liabilities of such dues of the buyer and seller would be jointly and severally, and government at its discretion is entitled to recover such amount. So in case of sharing, in case there are more than one parties involved, then the government will decide how to recover the amount. This was the case. So it was said that spectrum is a natural resource, and as under Section 4 of the Indian Telegraph Act, the government has the sovereign right over it. And the court considered it appropriate that the various questions should first be considered by the NCLT. Let NCLT consider the aforesaid aspects and pass a reasoned order. After hearing all the parties, court makes it clear that it being a jurisdictional question, it requires to be gone into at this stage itself. Regarding sharing, regarding trading, payment of dues of AGR, so there were various questions involved. Regarding sharing, it held that only part of the spectrum of the license has been shared with in the case of some of the telecom service providers, which have been approved by the DOT under the sharing guidelines. And there is no provision for the liability of the past dues on the shared operator. Even otherwise, the past dues of sharing operator license covers AGR for the spectrum used by holder of license certain telecom service providers, such as Reliance came into existence later on. And as observed here and above, the liability of such operator of the AGR would only be to the extent it has used the said spectrum. And shared operator TSPs cannot be settled with the liability to pay the past dues of AGR of licensee that have shared the spectrum with the original licenses. Now regarding trading, it is apparent that it was known to the parties that AGR dues to be finalized as per the decision of this court in a pending matter, and list was pending for the last 20 years. The liability cannot be escaped as specified in the trading guidelines to the extent that the seller or buyer is liable. They have to pay the AGR as per the judgment rendered by this court. The purchasers who are not seller or buyer shall have to pay the dues to the extent they are liable under the guidelines. So there were various issues in this case. So directions issued, what were the directions issued? That for the demand raised by the Department of Telecom in respect of the AGR dues, based on the judgment of this court, there shall not be any dispute raised by any of the telecom operators, and that there shall not be any reassessment. That in the first instance, the respective telecom operators shall make the payment of 10% of the total dues as demanded by DOT. Then telecom service providers have to make payment in yearly installments. Various companies through managing director, chairman, or other authorized officer to furnish an undertaking within 4 weeks to make payment of arrears as per the order. And existing bank guarantees that have been submitted shall be kept alive by telecom service providers until the payment is made. And in the event of any default, interest would be payable as per the agreement along with interest and penalty. So this was the brief judgment in Union of India versus Association of Unified Telecom Service Providers. So the main issue was whether spectrum can be subjected to proceedings under the code. So it said that spectrum is a natural resource and the government has the sovereign right over it. Another question was whether code overrides the provisions contained in Indian Telegraph Act, Indian Wireless Telegraphy Act, and Telecom Regulatory Authority of India. And in case of sharing, how the payment is to be made by telecom service providers. And in case of trading, how the liability of the seller and buyer is to be determined. So the court gave a detailed judgment on the various aspects. Next case was this K. Kishan versus Vijay Nirman Company Limited. So in this case, there was an arbitration award which has been passed against the operational debtor, which was not finally adjudicated upon. So the matter was ongoing in arbitration proceedings. Arbitration award also had been passed, but it was not finally adjudicated upon. So issue was whether code can be invoked in respect of operational debt where an arbitral award has been passed against the operational debtor which has not yet been finally adjudicated upon. So it said no, because in case an arbitration award is there, but it has not yet been finally adjudicated upon, maybe because the appeal period has not yet expired, or maybe due to some other factor because of non-payment, etc. So it said that in this case, the provisions of the code cannot be invoked because there is a pre-existing dispute which has not yet been settled. Whether Section 238 of the code supersedes Arbitration and Conciliation Act, Supreme Court held yes, where there is inconsistency, but in present case there is no inconsistency because of course arbitration award is there, but it has not yet been finally adjudicated upon. Next case was SBI versus Metenre Limited. So in this case, the issue was whether RP, he was earlier in service with SBI, then he passed the exam, he became an insolvency professional, and he was representing the SBI, the financial creditor. So the question here was कि a person who has been in service of the financial creditor and is still drawing pension from the financial creditor, whether he can represent such a financial creditor in the capacity of RP. So the issue here was whether an IP who had been employment of FC, which was SBI in this case, and he was earlier an employee of the SBI, then or after retirement, he was getting pension also, and then SBI engaged him as an RP. So the question here was whether an IP who had been in employment of FC can be appointed as RP and whether it would not amount to conflict of interest. Supreme Court said yes, there is no conflict of interest as such, and he can very well be appointed as RP. Although in this case, the RP was at a later date removed, but Supreme Court said it should not be taken as a precedent, and we cannot say that simply because he has been in employment of the SBI, he cannot be appointed as IP. Next case was Manish Kumar versus Union of India. So in this case, the petitioners were the home buyers. So there were various points. नीलम जी दरवाजा बंद कर लो या थोड़ा धीरे बोल लो वो इसमें आवाज चली जाती है. So in this case, there were 2-3 points. One was that the minimum number of creditors / allottees, they were defined. Next is ineligible corporate debtor can initiate CIRP against another CD. Third was whether the new management to make a clean break with the past and start on a clean slate. So these were the various issues. Issues were here the validity of amendments made under Section 7, subsection 1, Section 11, and insertion of section 32A, impugned amendments. So these were all challenged. But Supreme Court held that all these impugned amendments, they are held valid, and amendment to section 7 subsection 1 is prospective for pending applications. 2 months period was given from the date of order. Because in this case, what was the issue? Prior to this amendment, even one home buyer could initiate an application under section 7. But after this amendment, there was a minimum threshold of at least 10% of the project cost, people representing 10, home buyers representing 10% of the project cost, or minimum 100 number of buyers. Only such minimum number could move an application. But this amendment to section 7 subsection 1, it was held prospective. And another question came, what will become of applications which are pending on this date, on the date of the amendment? So for pending applications, 2 months time period was given from the date of order, that either within this period you comply with the conditions of 10% of the cost of the project, or minimum 100 numbers, or your application will be deemed to be withdrawn. Another was regarding explanation to section 11, and it was held that explanation to section 11 is clarificatory in nature and it is applicable with retrospective effect. Okay. If we go to section 7 subsection 1, I think we have already covered it while dealing with section 7, but let me just yes. So there was a proviso which was added to section 7 subsection 1. It says, provided that for the financial creditors referred to in clauses A and B of subsection 6A of section 21, an application for initiating CIRP against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total number of such creditors in the same class, whichever is less. So this was the minimum number, either 10% or not less than 100. Provided further that for financial creditors who are allottees under a real estate project, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. So 100 or 10% of the total number of such allottees. So this was the condition for filing an application after this amendment. But prior to this amendment, and this amendment came with effect from 28th of December 2019. But now the question came, what will become of applications which have been filed prior to this? So they said we give 2 months period to comply with this condition. And another was regarding explanation to section 11. So let us again go through the explanation to section 11. Explanation to section 11 says, for the purposes of this section, a corporate debtor includes a corporate applicant in respect of such corporate debtor. And for the purpose of this section, it is hereby clarified that nothing in this section shall prevent a corporate debtor referred to in clauses A to D from initiating corporate insolvency resolution process against another corporate debtor. Because section 11, we know, is regarding the persons which are not entitled to make an application. But a corporate debtor which is undergoing CIRP, it can initiate CIRP against some other person. Okay? From whom he has to recover some debt. So it said that this explanation to section 11 is clarificatory in nature and it is applicable with retrospective effect. Next case was P. Mohan Raj and others versus Shah Brothers Ispat Private Limited. The related sections here were section 138 and section 141 of Negotiable Instruments Act, section 14 of IBC. So in this case, checks were returned dishonored on 3rd of March 2017. On 31st March, demand notice was issued under Section 138 of Negotiable Instruments Act. Two criminal complaints were lodged on 17th May 2017 and 21st June 2017 under Section 138 read with Section 141 of the Negotiable Instruments Act. And on 12th of February 2018, summons were issued to the company. So this was the proceedings under Negotiable Instruments Act. Now simultaneously proceedings were there in IBC. On 21st March, Section 8 notice was issued by the operational creditor. On 6th June, CIRP was initiated and moratorium was implemented. And on 24th May 2018, adjudicating authority stayed proceedings against two criminal complainants. So the issue was whether, because as per the provisions of IBC, Section 14 disallows any proceedings when CIRP is going on. So whether the scope of Section 14 of IBC, it would cover the magnitude of the Negotiable Instruments Act also. So whether any proceedings can go on despite Section 14 being in vogue, this was one of the issues. Another was, is it permitted to initiate the check bounce proceedings under the Negotiable Instruments Act or to continue the proceedings against the debtor company and its directors when the debtor company is about to resolve its bankruptcy issue or in an ongoing corporate insolvency resolution process? So what is the status of interplay in case there is an interplay between Negotiable Instruments Act and IBC? So it said the decision was that Section 138 oblique Section 142 proceeding is against the corporate debtor. Okay. It says the proceeding under Section 14 is not against the director. It is against the company. It is against the corporate debtor and it is covered by Section 14(1)(c), 14(1)(a) of the IBC. And this moratorium, it would apply only to the corporate debtor. The natural persons mentioned in Section 141 continuing to be statutorily liable under Chapter 17 of the Negotiable Instruments Act. So it said that Section 141 applies to only natural persons because natural persons only can be imprisoned. And this Section 14, it applies to companies, not to individuals. And then Bombay High Court and the Calcutta High Court judgments in Tile Cotton Private Limited versus State of Maharashtra and MBL Infrastructure Limited, they were set aside. So it said that, of course, proceedings can go on against the directors. And proceedings under Section 138 of Negotiable Instruments Act are quasi-criminal in nature and there cannot be any moratorium to such proceedings. Next case was Gujarat Urja Vikas Nigam Limited versus Amit Gupta and others. So in this case, brief facts was that there was termination of power purchase agreement. Pawan Singhal ji, हाँ please. हाँ पवन जी पूछिए. पवन जी आप पूछ सकते हैं. पवन जी, you want to ask something?
हाँ जी. ये जो सेक्शन 138 में अभी आपने बताया कि कंपनी के अगेंस्ट में जो है मोरेटोरियम एप्लीकेबल हो जाएगा और कंपनी के अगेंस्ट में कोई प्रोसीडिंग नहीं होगी लेकिन डायरेक्टर के अगेंस्ट में हो जाएगी, करेक्ट?
हाँ.
लेकिन अगर डायरेक्टर की जगह कोई ऑथराइज्ड सिग्नेटरी ने चेक साइन किया है तो
भी उसी के अगेंस्ट में होगी ना. एज एन इंडिविजुअल वो होगा. कंपनी, देखिए ऐसा होता है ना भाई, कंपनीज एक्ट में क्या बोलता है? कंपनीज एक्ट में क्या होता है, जैसे कोई ऑफिसर इन डिफॉल्ट है तो प्रोसीडिंग्स कैन बी अगेंस्ट द कंपनी एज वेल एज द ऑफिसर इन डिफॉल्ट. सो हियर ऑफिसर इन डिफॉल्ट विल बी सब्जेक्टेड टू द प्रोविजंस ऑफ सेक्शन 141 ऑफ द नेगोशिएबल इंस्ट्रूमेंट्स एक्ट. उसके अगेंस्ट में मान लो इम्प्रिजनमेंट है, कंपनी को तो वैसे भी नहीं होनी इम्प्रिजनमेंट, है ना? इम्प्रिजनमेंट तो इंडिविजुअल को होगी ना, तो उसके अगेंस्ट में चल सकती है प्रोसीडिंग क्योंकि क्वासी क्रिमिनल नेचर की है.
Even if that employee has left the organization.
लेफ्ट होने से क्या होता है, उससे कोई प्रॉब्लम नहीं. वो तो वो कॉज ऑफ एक्शन की डेट पर देखा जाएगा. ऐसे तो सारे चेक बाउंस करा के चले जाएं कंपनी से, उससे कुछ नहीं फर्क पड़ता. नेक्स्ट केस इज गुजरात ऊर्जा विकास निगम वर्सेस अमित गुप्ता एंड अदर्स. सो इन दिस केस देयर वाज अ टर्मिनेशन ऑफ पावर परचेज एग्रीमेंट by Gujarat Urja Vikas Nigam Limited. So in the agreement, it was written that Gujarat Urja Vikas Nigam Limited can terminate the power purchase agreements if CD goes into liquidation. Okay. So there was a termination of power purchase agreement. Now, suppose there is an agreement of power purchase and whether that can be terminated if the company to whom the power is being supplied goes into liquidation. So this was the issue basically. So issue was whether NCLT oblique NCLT can exercise jurisdiction under IBC over disputes arising from contracts such as the power purchase agreements, because this was a dispute between these two parties. Now, whether the NCLT and NCLT, they have a jurisdiction to entertain such sort of disputes which are arising from contracts such as the power purchase agreements, and whether the appellant's right to terminate the power purchase agreements in terms of Article 9.2.1e read with 931 is regulated by the IBC. So the Supreme Court held that NCLT oblique NCLT, they could have exercised jurisdiction under Section 60, subsection 5, subsection C of the IBC to stay the termination of the power purchase agreements by the appellant, since the appellant sought to terminate the power purchase agreement under Article 9.21e only on account of the CIRP being initiated against the corporate debtor. So actually the cause given, the reason given for termination of the power purchase agreement by this Gujarat Urja Vikas Nigam was that since your company has gone into CIRP, so we are terminating this agreement. So because this was the reason given, so NCLT and NCLT, they could have exercised jurisdiction under Section 60, subsection 5, subsection C. Because Section 60, what Section 60, subsection 5 says, let us see. Section 60, subsection 5C says that any question of priorities or any question of law or facts arising out of or in relation to insolvency resolution or liquidation proceedings of the corporate debtor or corporate person under this code. So Supreme Court was of the view that NCLT oblique NCLT, they could have exercised jurisdiction under Section 60, subsection 5 because it emanated from CIRP. Because the cause given was CIRP. Second is NCLT and oblique NCLT correctly stated the termination of the power purchase agreements by the appellant, since allowing it to terminate the power purchase agreement would certainly result in the corporate death of the corporate debtor due to the power purchase agreement being its sole contract. भाई ये पावर परचेज एग्रीमेंट ही तो इनका मेन कॉन्ट्रैक्ट था. अब अगर यही टर्मिनेट हो जाएगा तो इसमें इस कंपनी को कौन खरीदेगा? Nobody will buy this company. It will result in corporate death of the corporate debtor. And third point was we leave open the broader question of the validity oblique invalidity of ipso facto clauses in contracts for the legislative intervention. So said by the reason which you are giving for termination is initiation of CIRP. So naturally NCLT and NCLT have the powers. And our idea is this IBC being a beneficial legislation to the CD. Our idea is not to say expedite the death of the corporate. Next case was regarding this Arun Kumar Jagtramka versus Jindal Steel and Power Limited. So in this case, the issue was that whether in a liquidation proceeding under IBC, the scheme for compromise and arrangement can be made in terms of section 230 to 232 of the code. And if so permissible, whether the promoter is eligible to file application for compromise arrangement while he is ineligible under section 29A of the code. Because 29A, as we know, it restricts certain types of resolution applicants to file an application as a resolution applicant. But suppose the company is now under liquidation. So whether that restriction to promoters who are ineligible under section 29A, whether that restriction still travels to the liquidation portion also when a scheme of compromise and arrangement is being initiated. So Supreme Court said yes, as per the provisions, this compromise and proceedings, it has to be done within the 90 days period. And prohibition is placed by the Parliament in section 29A and section 35(1)(f) of the code. They must also attach itself to a scheme of compromise or arrangement under section 230 of the Act when the company is undergoing liquidation under the auspices of the IBC. So, if there is a resolution applicant who was ineligible under section 29A, such person cannot initiate a scheme of compromise or arrangement in liquidation as well. Next point was here, Lakshmi Pat Surana versus Union Bank of India. So this was in this case, the issue was whether an action under section 7 of the IBC can be initiated by the financial creditor against a corporate debtor, against a corporate person, concerning guarantee offered by it in respect of a loan account of the principal borrower who had committed default and is not a corporate person within the meaning of the code, and whether an application under section 7 of the code filed after 3 years from the date of declaration of the loan account as NPA being the due date of default is not barred by limitation. So in this case, the question was the guarantor, he was not a corporate person and section 7 application was filed. So the issue here was whether action under section 7 can be initiated by a bank against a corporate person being a corporate debtor concerning guarantee offered by it in respect of a loan account of the principal borrower who had committed default and is not a corporate person within the meaning of the code. Guarantor is an individual. Guarantor is not a corporate person. And you are filing an application under section 7. Whether it is permitted? Yes, it is permitted. Because section 7 itself says it talks of filing of an application against the corporate person, and guarantor is very much covered by this section 7. So yes, CIRP, this section 7 application can be initiated against an individual also who has stood guarantee for a corporate loan. And whether this application under section 7, which has been filed after 3 years from the date of declaration of the loan account as NPA, is not barred by limitation. They say the date of last acceptance is to be considered, because in this case there was acknowledgement of liability at various stages, and the last point was 8th of December. So as last as 8th of December, this liability was acknowledged by Lakshmipat Surana. So it said that it is very much within the limitation period. So I think we can stop here, and after 5 to 7 minutes of break, we will again resume. So we are ending the meeting now, and you can again join with the same link. Thank you very much.